Okay, so week 13, first thing I want to cover with you is an introduction to free exercise. We have now covered the Establishment Clause, right, the first of the two religion clauses. Under the Establishment Clause, once you're done citing your text, right, and don't forget, right, selective incorporation, if you've got a state or subdivision of a state that you're suing. Once you're done covering your text, you go ahead and sort out what kind of a fact pattern you're in, right? Is it government aid, or is it a display on public property, or is it something going on in schools, right? And you apply the appropriate test. Now, as I've mentioned before, at a macro level, when you're looking at the two clauses, right? Establishment clause is what you use when you think the government is promoting religion, and free exercise is what you use, generally speaking, when you think that the government is interfering, right? Because exercise something, right? I've written about this. To exercise something means to put it to use, right? It is kinetic and active. So when I'm either practicing my religion or practicing my non-religion, right? Expressing my belief, or in the case of somebody who's religious, participating in, if I'm participating in church services. Now, we've seen some interesting cases here develop. I'll talk about that later. I want to talk about the rules first, but generally speaking, right, free exercise means services, sacraments, rituals, rites, prayer, expression of belief, that kind of thing, right, is free exercise of religion. So the government is not supposed to interfere with us when we do that. Okay, now here is the problem, right? So again, this video is just going to be sort of a brief introduction, and then we'll get to the nuts and bolts of how it works later, but I want to set this up first. Courts have had to decide whether they can view the free exercise clause as an absolute, and I've talked to some of you about this individually. By now you're pretty used to the idea, I think, that, right, courts don't really treat rights, whether they're enumerated or unenumerated, right, as absolutes. Courts try to reach some place, right, where we're being reasonable, right, about how that right how it works and how it would apply. And this is no different. Could it be that could a court really hold, the Supreme Court really hold, that the government is never allowed to do anything, right, that would interfere with somebody's stated religious beliefs? Number one, if that's the rule, right, the state can never, the government can never interfere with anything, right, that I claim to be, that I state to be part of my religious beliefs. Then the next time I get pulled over for speeding, or you do, right, what you do is you roll down the window and say, I'm sorry. In my belief system, I am required to reach a velocity of at least 90 miles per hour, right, in order to commune with the Almighty. If I'm not going at that speed, I'm not able to commune with the Almighty, and therefore your speed limit, the one you're trying to enforce, interferes with my free exercise of my religion, and you need to go away, because the government can't do that, right? How many people would suddenly develop religious beliefs that prevent them from paying taxes, right? So we got to be careful about this. I'm half joking, but I'm half not. Some of you may have heard of this ridiculous outfit that calls themselves Pastafarians, and right, they claim to worship a flying spaghetti monster, right? And actually won a lawsuit. It was overseas, but won a lawsuit to wear spaghetti colanders, right, as headgear. All these ridiculous kind of stunts, right? So that's kind of a ridiculous illustration of the problem, but but it is an illustration of the problem, right? People can claim to believe anything, and if any government law that interferes with somebody's claimed religious beliefs would be invalid, we would be opening the door to invalidate virtually every law. So we have to find some way, right? Says the court, to apply the free exercise clause in a way that protects people in their religious beliefs and practices, right, but does not yield absurd results. So the rule that has developed, and we'll put meat on these bones in a later video coming soon, but the general rule that has developed is this. With any rule of general applicability, right, with any rule of general applicability, a generally applicable, these are the magic words, a generally applicable law, right, a law that applies in an even-handed way to everybody, right, that does not provide for an opportunity for the government to target people individually based on their religious beliefs, right, so a law that doesn't do that, a law that does not contain exceptions, right, here and there, a law that is generally applicable, right, treats everybody the same way, and there is nothing suspicious about it in terms of, right, specifically targeting religious beliefs or practices. That kind of a law will not be struck down, right, or will not be declared unconstitutional, right, in a free exercise case. There is no free exercise violation, right, if the state is enforcing a generally applicable law that applies to everybody, right, where there is no opportunity for individualized hearings or, right, opportunities for the government to make one decision with this group and another decision with this group, right, another decision with this group or individual, right. And we're going to talk more about this, but there's no built-in hearings, right, or opportunities to mess around like that with people. There are no exceptions, right, right, where again the law can selectively be applied, right, here and there. In that case, there is no free exercise violation. So that would be a lot of cases, right? Because a lot of laws are generally applicable. A lot of laws just say what? If you're on the highway, on this highway, you're going 70 miles an hour or less, and that's the end of the story. There's no individualized hearing for whether you're allowed to go over 70, right? There are no exceptions about that. Now, you know, police officers may enforce it, you know, in a spotty way. I'm talking about the law itself, right? There are no built-in hearings to the law as to who has to drive under 70 miles an hour, right? And there are no exceptions as to who has to drive 70 miles an hour. There's nothing on the face of the law that looks like it's targeting people's religious beliefs or practices, right? So in that kind of a law, there is no free exercise violation. In other words, if it's a generally applicable law, you better have some other claim to go along with your free exercise claim, because your free exercise claim is going nowhere, right? So maybe you have an equal protection claim, maybe you have a substantive due process claim, but your free exercise claim, if it's a generally applicable law, is going nowhere. So in the next video, we're going to talk about the circumstances under which a court would say, first of all, do the general rule, right, by general applicability, and this employment division versus Smith case. And then we'll talk about the two ways, right, the two circumstances under which a court might say that a law is not generally applicable. And what we're going to find out is that when a law is not generally applicable, courts apply strict scrutiny, and you know what happens then, big trouble for the state, right, big trouble for the government. So stay tuned for the next video, but I wanted to at least get this thing up as soon as possible, right, this introductory video. So stay safe, and we'll be back soon.